Good morning, everyone, and thank you. I'm sorry we're a few minutes late. We had a lot of people to bring in. I'd like to welcome you to the last series for this year of our webinars on estate planning. We have three excellent presenters, so it's going to be jam-packed. I would also remind you that your microphones are off. Katia has asked you to keep your cameras off. The presenters will be presenting to you. We don't have a lot of PowerPoint today, so they'll be talking face-to-face with you, so that will be very interesting. You will be getting a copy of the recording, so this is being recorded, so that people throughout Quebec can access the information and resources for those who were not able to attend today and our partner organizations. So that's why it's so important to keep those mics closed so we have a professional product at the end of the day. First of all, I would like to thank our funders, who are the Secrétariat des Québécois d'Expression Anglaise and Éducaloi. And when we send out the recording, you're also going to receive a survey. It's absolutely essential that you complete that survey, and it'll take you 3 to 5 minutes max. Just hit submit and it comes directly to us, and we get an analysis of how you found the session. And that's important for our funders. Questions will be presented after each presenter. So as you think of a question, as your presenter is speaking, please type it in the chat box. That lets everybody see what question's been asked, so we avoid duplication. It also prepares Katia in advance so that she can bring up the questions immediately, that we're not waiting and scrambling for someone to think up a question. We have 10 minutes for question period. There will be one break where people can stretch and get a cup of coffee. And without further ado from me, I'm going to introduce the first presenter, and who is a financial advisor and an expert in his field, Danny Sirgnano, and I hope I pronounced the name right. I have a terrible time with names. Danny is the owner and managing director of Sirgnano Financial Services. He has been helping clients build their financial futures that they want since 1998, when he joined IG as an advisor. Since then, he has worked through Berkshire, Manulife Investments, and the IPC Group along his path to building his own firm.
Yes, I've got it. Yeah.
Close your mic, please.
Okay, bye.
Danny's specialty lies in the development of plans that helps his clients balance their current lifestyles with their future needs and objectives. Never one to shy away from hard conversation, Danny puts his clients first and ensures they receive the expertise and information he and his team provides to build what is important to them. Danny's strong analytical and detailed approach to his work in the financial service field was born from his training and previous career as an aircraft maintenance engineer. In this role, Danny developed custom solutions to major technical hurdles faced by his clients the world over. This love for aviation has stayed with Danny and can be seen in his community work. Danny is a notable supporter of the Royal Canadian Air Cadets Program 6890 Lakeshore Squadron. Danny is also a supporter of the West Island Palliative Care Center. Danny is a proud father of 2 adult sons and even a prouder grandfather of a lovely granddaughter. An avid traveler, scuba diver, movie buff, and reader, Danny is always ready to strike up a conversation over a glass of wine, another one of his many interests. As a strong believer in constant improvement, Danny is a few months away from completing an MBA, a challenge he decided to take on with one of his sons in the beginning of 2020. So without further ado, if you all received your agenda, I am going to turn it over to Danny, who is going to talk about the importance of us preparing our finances and how to reduce the tax burden on the state through proper tax planning. and everything else that we need to know. Not my area of expertise. So Danny, it's all yours.
Thank you. Welcome, everyone. Today, we're going to talk a little bit about the estate planning. An estate plan is really the final chapter of a financial plan. Starting a financial plan at the earliest possible moment is greatly beneficial. It's never too early to start to plan. Okay, from the expression cradle to grave, starting off, our children, our grandchildren, having them start off to learn how to set aside a certain amount of our disposable income for one day. Okay, when you look at most people, they start off with a financial plan, looking at savings for their homes or savings for the things that they want to do. The financial plan naturally develops into a retirement plan. And when people develop a retirement plan, typically we use products, registered products like RSPs or LIRAs or RIFs. All of these products are sponsored or helped out by the government or promoted for the individuals to put away money for the years when they're drawing down funds from their accumulated savings. Basically, there's a couple of different types of asset classes. You can use registered investments, which would be like the accumulation phase would be RSPs. And at age 71, an RSP has to be converted into a RIF. An RSP is an accumulation account. I liken it to a file cabinet, a 2-drawer filing cabinet. And the first drawer, the upper drawer, is your RSP, and you're allowed to put in monies that are going to grow tax deferred, which means that while you're putting these monies away, the government will give you a break on taxation. But at a certain age 71, is the outer limit where you cannot keep the money inside an RSP anymore. So I tell people, think of the file drawer being closed, and now everything that was in that filing drawer, the bottom of the drawer gets cut out, and everything that you had saved inside your RSP can fall down into your RIF, or registered income fund. The registered income fund, the second drawer, it's got to be opened up, and now that drawer is an exit drawer. Monies that you have accumulated over the years now have to be withdrawn, because the government basically wants you to take out that money so they can tax you on your income. Okay, so in an estate plan, one of the errors that many people make is that when they bequeath their holdings, they don't distinguish the difference between a registered plan and a non-registered plan. Registered plans carry a taxation burden. So if you allocate those resources to anyone other than a spouse, the RSP or RIF money is fully taxable. Okay, so preferably you'd want to leave your registered plans, your RSPs, RIFs, locked-in retirement accounts, those types of plans, you'd preferably leave them to your spouse. Okay, and if you choose, leave other assets, non-registered assets, to other people. Okay, if there's people who are important to you, leaving them your registered money comes with a very large tax burden. Whereas a spouse, it's called spousal rollover. So the monies that are inside a registered plan can be rolled over to the spouse without a at-source tax deduction on the immediate rollover. Okay, so very important. You'd want to make sure that in your will, you put in that your registered money should be going to your spouse if they're surviving you. Okay, it's much better for the people who are receiving it, because when you receive a registered plan, someone who is not a spouse, there's a tax burden that's immediately due. Okay, when we talk about the types of products that can be used for our retirement planning, there's products that are insurance-based products, And these products, actually, you can get products that carry a lifetime guarantee for payment. Earlier, Ruth and I were talking about being conservative and, people being worried about longevity or their lives lasting longer than the money that they've saved up. Well, some of these plans pay for life. So even if you've withdrawn all the money, they will continue to pay you for as long as you're alive. So this is something that, it's not generally known by the saving public. So plans like your registered plans, they can be allocated into these types of insurance products where they act, your RSP or your RIF can act as a defined benefit pension plan. So that's the type of plan that we used to see quite often in government organizations or very large companies, where you got a certain amount of money for, on a monthly payment for the rest of your life. Okay, so you can actually become the owner of that type of plan and own it personally. Those products are called segregated funds. Okay, and they fall under the category of called GMWB products. Okay, that's something to be aware of, because you can buy those products till the age 80. So for people who are looking at planning for a more successful, less taxed estate, that's one of the products that you should be looking at. Also, there's other products which are, again, insured. The reason why we use a lot of insurance products is because of their preferential tax treatment. So there's another type of product, say a regular segregated fund, where the value of the investment, it's invested inside the market, but the insurance company provides a guarantee for the value should you come to a sudden death. And for example, the market is severely depressed, like areas that we're going through now, difficult markets, where the money that you put in, the value is less than the money that you put in. Well, there are products that will guarantee the capital that you've put in. So this is a very prudent tool to use. The returns are, shall we say, not the best, but they are amongst the best. So you're not really giving up a lot of return for getting a product that carries a guarantee. When we look at different ways to protect an estate, the use of insurance products, there's insurance that's called term insurance, which is temporary insurance. And these insurance policies, people have them, you hear it all the time, I have a term 10 or a term 20. So there's policies that are designed to last for a 10-year period. And after a 10-year period, the price changes because now you're 10 years older and the risk of you passing away has increased. So these policies can be renewed till age 70, or in some cases 75, depending on the company that you're dealing with. And they will terminate by age 80 or 85. So in those term policies, if you live past that age, there's no longer any insurance coverage. So when you're buying an insurance policy, you have to understand what it is that you're purchasing. Okay? A term policy means just that, it will last for a term. The second type of insurance policy is something called a permanent life policy. A permanent life policy basically will pay out to the beneficiaries at no matter what age that you pass on. So if you live to 87 or 89 or 93, whatever the age is, that policy will pay out to your beneficiaries. There's a couple of different types of those permanent policies. One of the policies is just the death benefit face value. So if you had an insurance policy, say that's $100,000, upon death, the people that you chose as your heirs would receive that benefit tax-free. Insurance payouts are tax-free. Okay? Second type of policy is an insurance policy, again permanent, where you have cash value accumulation inside the policy. So for example, of a $100,000 policy, that number upon death can increase because the insurance policy has a feature to it that allows you to accumulate money in a tax-free environment. So insurance is the only other area where you have a tax-free potential for growth. And that's not tax deferred. It's very different. In your tax-free savings account, monies that are earned are not taxable. And in insurance policies, monies that are earned by the additional deposits inside the policy also grow tax-free. So when the policy is being paid out, the death benefit is being paid out, the face value of the amount of insurance is paid out plus the additional growth of the extra money, which grew tax-free. So those policies can have very large balances. You can actually squirrel away a significant amount of money inside of those policies and avoid paying taxes on the estate paying taxes. Another type of policy that is in a permanent category is a whole life policy. And these policies, you can purchase them for grandchildren. I can tell you, I did that for my granddaughter. When she was born, you can buy an insurance policy at a very young age. And with insurance, the sooner you buy it, the less you pay. So insurance is probably the most efficient way for an estate to transmit wealth because there's no taxation on it. And these whole life policies can accumulate significant growth, and all of that growth really accumulates tax-free. Now, oftentimes people will say, well, if I'm buying insurance, it's really not for me, it's for my heirs. The use of whole life insurance policies, along with another type of policy called universal life insurance policies, those policies, the cash value can be accessed by the owner of the policy. So monies that were put away can help you through in your retirement. And those benefits are, we call them, insured retirement plan. So monies that you squirreled away grew tax-free. You can borrow out that money from the policy and never plan to pay it back. And when you pass, the monies that are left will be transmitted to the heirs that you choose. So those are, in a few broad strokes, some of the major things that you want to consider when you're developing a financial plan that becomes a retirement plan. The retirement plan eventually will become an estate plan, but one leads into the other. So if you have a good retirement plan, then your estate plan will follow suit and provide the benefits that it should. It's very important that the people that you're working with understand what it is that's important to you. Speak with your advisor about the things that are important, because advisors, we don't intrinsically know. we have to be explained to. Tell us the things that are important, why it's important, and these are things that your advisor should be asking you about. Okay. I think that when you look at some of these issues, a lot of us are faced with, how should we say, there's information that we know, and then there's information that we know we don't know. And you could use the example of, oftentimes people say, well, I get dividends. Well, dividends are taxed differently than interest. Dividends are taxed differently from capital gains, but we don't know exactly how that formula works. It's a complicated formula. We know that they're taxed differently, but we don't know exactly how it works. And then there's the third type of information, is information that we don't know. And when you don't know that you don't know, it's not something that you can question someone about or ask, how does that work for you? So a financial advisor should be in the position to provide you with that information. Okay.
Hi, sorry, Danny, I was letting someone in, so I got distracted. Okay, so there are a few questions.
Okay.
So I'll start with the first one. It's, how can someone avoid a large taxation or on a RIF if they don't have a spouse and they only have one child?
Okay, unless that child has special needs, there will be taxation. So what we try to teach people is part of the advice that we give is if that RIF is placed into one of these GMWB products, they will get the RIF payout that they would standardly get. But we also teach people who have large amounts in their register plan to start taking out the money earlier. And because these products guarantee a payment for life, there's no downside to taking the money out earlier. But for someone who hasn't had the opportunity to draw down the RIF, unfortunately, when it's going over to their loved ones, if it's not a spouse, there will be tax upon them.
Okay. Sorry, the wind just gusted and I thought my window was going to break there. So another question, just when I was listening to you, is what happens if parents or seniors have children who live outside of the province or Canada? That's
Okay.
correct. Outside of Canada, the province. What are the steps to do for taxation purposes?
When you're looking at taxation, Canada looks at taxation as to people who are living here. People who don't live here, like we have people who leave the country, or there's typically a flat tax, and that flat tax is 25%. So, for example, if someone decides that they're going to leave Canada and live in Ireland, well, they can take out all of their RSPs in one withdrawal. The government will withhold the 25%, which may be lower than their effective tax rate when they are living in Canada. So this is something that a financial advisor would work with the client on, determining where they're going, what the tax treaties are for the particular country that they're going to, and work out the way to pay the least possible tax. But there is, unless there's a tax treaty with the countries, there really isn't a big advantage tax-wise for planning for somebody outside the country.
Sorry, I forgot to unmute. A few questions have come in. One is, can cash be taxed?
Okay, cash is basically taxed when you are living. So if you have an open account and an investment account, and that account generates a return, the return that it generates can either come in the form of interest, it can come in the form of dividends, or it comes in the form of a capital gain. So interest is taxed fully dollar for dollar, and it gets added into your accumulated earnings. Okay, so if you have $100 of interest, that $100 will be added to your income, and tax is due on the $100, and that will be added to the top line of your income. So if you're earning $40,000 a year and you earn $1,000 a year of interest, well, that $1,000 pushes up your taxable income to $41,000, and you will be taxed at the specific tax rate for the amount of money that you earn. If you receive that $1,000 in dividends, dividends are taxed roughly at 2/3 per dollar. So 1/3, 66 cents is taxed, and 1/3 is not. So the tax rate effectively is a little bit lower. And capital gains, if you earn $100 capital gains, 50% of that is not taxed. And that's the law presently. So the 50% of the $100 that you earned are not taxed, and the other $50 are taxed at your tax rate. Okay. So that's going to change how your earnings are taxed. So cash accounts, if it's earning interest, you'll pay tax on interest. If it's earning dividends, you're gonna pay tax on dividends. And if you use that cash account to buy something and then sold it at a profit, that's called a capital gain, and that will be preferably taxed, because only half of it will be taxable.
Okay, I think Danny has Okay, you're back. So I just have, there's, Ruth, how many more questions do we have time for?
Can you hear me?
Yeah, I can hear you. Yeah, should I
Yeah,
do two more?
you're good because Danny caught up with the time we started late, but Danny finished right on the original agenda. So I think
Okay,
we could
perfect.
probably take another 3 or 4.
Perfect. Okay. So there's a question here on insurance policies, Danny. So the question is, the person would like some clarification on both whole life insurance policies and universal life policies. So this person wants to know, both of these policies let you borrow
Yes.
from them, and you don't have to pay back on what is left when someone dies and the money goes to the
Yep.
heirs and it's tax-free, right? That's what they wanted
Sure.
clarification
Yes,
on.
that's correct. Think of it this way. Think of your policy as being the death benefit amount is the amount of insurance. When you have a universal life policy, there is a side bank account. That side bank account is managed with the advisor. You will choose investments that the insurance company provides that can be placed inside of that universal life policy. When you borrow money against those policies, basically the threshold is about $50,000. If you have more than $50,000 in the account, that's the side account that's attached to your universal life policy, you can actually go to a lending institution like a bank. You don't necessarily have to borrow the money from the insurance company. And the bank will take that $50,000 as collateral for their loan. Okay, and they'll give you up to 75% of the amount of money that's in that side account. That's for a universal life policy. And some people have accumulated significant dollars inside the universal life policy because there's flexibility of the premium. Your deposit is not fixed. Okay. In a whole life policy, your deposit is fixed and you have no say as to what the investment selection is. The insurance company provides the investment options. They carry them out. You have no say. However, for giving up the selection process of the investments, the insurance company guarantees the value. And in those policies, the banks will actually lend up to 100% of the extra cash. So this is something to be aware of when you're looking at what type of policy you want to buy and how you want to use it. Okay, is that answered?
I think it must, yeah. The next question is, again, it's on insurance policies. So the question is, can insurance policies be used to offset races on inheritance of RRSPs?
Okay, when people look at their financial planning, when you're setting aside monies into a registered plan, your advisor should teach you a couple of things. Okay? One of the things I'm going to teach everyone here, it's a rule of thumb that is very, very useful. It's called the rule of 72. We take the number 72 and divide it by whatever rate of return we are expecting to get. So let's just use 7%. So if you have 72 and you divide it by 7%, it will take 10 years roughly for your money to double at 7%. Okay, so knowing that, we can also see in how many years, at what rate, we can estimate pretty accurately how much money someone will have with the deposit into their RSP. So let's use the number 72, and we take 72 and we assume a 7% rate of return. We know that every 10 years the money will double. So if a 40-year-old has $100,000 in their RSP, by the time they're 50, they have 200,000. By the time they're 60, they have 400,000. By the time they're 70, they have 800,000. And this is without adding any additional funds. So your advisor should be calculating out that when you retire, let's say at 70, you have $800,000 in your RSP. So that $800,000 at age 71, you are required to withdraw a little over 5%, 5.38% is what you have to withdraw. So knowing this information, you should be planning to optimize how much money you put away in your RSP, because if you saved it today but paid it tomorrow, the advisor didn't really help you. Okay, so what you want to do is calculate how much money is optimum to put away so that your future tax bracket is calculated to be no higher than your present tax bracket. Okay, so this is a quick way for you to basically say, okay, how much money should I be putting away in my registered plan? And how much money will I have when I retire from the money that I've set aside today? And because we know that this number of, so rule of 72 works very, very precisely. If we assume a 5% rate of return, okay, it's going to take about 14 and a half years for our money to double. And we start at the very end. We start, okay, when I have to take out money, how much will I need? And work backwards from there. Okay, so everyone can do a really quick calculation to say, okay, if I need $40,000 a year when I'm 71, how much do I have to put away? And they work backwards from the amount of years it takes for them to double. And it'll give them a pretty good indication as to where they should be.
Well, on that note, someone asked a question if you're not able to contribute for some years to your TFSA, can you then pay cash and catch up on the years that you lost?
Yes. The deposit room, and this is something not too many people understand. The deposit room of a TFSA is cumulative, just like your RSP is. Okay, so if you don't make, because of your financial situation, you're not able to put away the money into your TFSA, you can pick that up later on. Okay. One of the other things that is very important for people to understand is that if you take money out of your TFSA, that money that you take out, the preceding year, you can re-put it back into your TFSA. So if somebody, say, has $50,000 in their TFSA, and this year they can't put any more money, but they have a room of $80,000, well, next year they can put in the monies that they didn't put in this year. And in the case of somebody who has, say, $50,000 in their plan, and they take out $10,000, next year they can replace that $10,000. Okay, so that's something quite important. One of the things that we teach people is that you want to supplement your income with revenues generated by your TFSA, because that money comes in without taxation. So it's net dollars. And we all live with net dollars, but nobody really talks about that when you talk about your income. Everyone talks about their gross income, but you never really see the gross income. You only see the net dollars. So we try to teach people to work with net dollars. It's a better way to plan.
Okay.
Okay.
Ruth, can I squeeze one more in?
Yep.
Okay. There's a question here which I think is important to ask. When someone passes away, if they have children, is their bank account taxed to their children or to the inheritors of any bank accounts?
Usually,
Yeah.
I understand what you're asking.
Thanks. I've had one coffee.
In a bank account, typically there's not much earnings because the banks don't really pay you to hold your money. Okay, so if the money is inside the bank account, the amount of interest earned is trivial. Okay, and typically that isn't reported. It's just goes in the calculation, but there isn't a lot of money that's going to be earned unless someone's holding a significant amount of cash in their checking account. It isn't an issue. And no, it's not taxed. The money that's inside a checking account is not taxed. Okay. Just the earnings if it's in a savings account. Savings account, you may get 1 or 2 or 3% interest, but even those dollars are rather small. Okay. So, but anything in a checking account typically is just rolled over into the estate account.
Okay.
Okay.
Well, Danny, thank you very, very much. And I think the one thing that I've learned out of this, that there's many different avenues that I completely do not understand. But at my age, I'm almost afraid the horse has already left the barn. But the one thing I think we all need to do for sure is touch base with a financial advisor. See if there's any time or any help that's available for some of us. But also, most importantly, is to have our children and our grandchildren, because I have grandchildren that are like 37 years old, that need to be looking at this kind of thing. And I know that I talk about wills with them and things like that. Have you got somebody named, God forbid, you're both killed in a car accident, and they don't want to hear anything about it. Mother, you're always doomsday. And I said, no, I'm not. I'm very practical. And I'm also somewhat discouraged, I guess, that I find that the bank just pays you nothing. So I would like to know, should my tax-free savings account be self-directed? And if it should be, then I guess I need someone to do that for me.
Well, just to give you an example, 30 years ago, if you invested into a bond, you could get a 7% rate of return. Okay, and a 7% rate of return was fair, and it's still fair today. But today you have to be in 9 different asset classes to get the 7%. Okay, in your TFSA, that's the source of most people's discretionary monies, because if you're earning over $45,000 a year, your effective tax rate is 37.38%. Okay, so I use a round number of 0.4. So if you need $100 and you have to take it from your registered plan, you have to take out $160 to get the net of $100. So saving up monies inside of your TFSA allows you to access money that you need for those extra expenses that happen occasionally, and that money should be working for you. So that there are products available that will pay out, a 5 to 7% return, and we teach people to use those products inside their TFSA, because the money that you take out of there can be replaced. If you have monies in excess of your expenditure budget, you can put the money back, and it can continue to grow for you.
So
yes.
Very, very important. And TFS, tax-free savings account, I think, are key venue for some seniors, especially those on limited income, because it's almost like a savings account where we can build some interest, not be taxed on it, but also if the fridge and the stove go, you can
Yes.
get the money immediately and replace those. So it's certainly a benefit. So I thank you, Danny. All
My
the
pleasure.
information has been absolutely superb. And I think my very last, just a yes or a no, do people need to worry that they have to have $25,000 to be able to go to a financial advisor and get some help, or can they go with smaller amounts?
Okay. Financial advisors set their own limits.
Okay.
So there are advisors that have a dollar minimum.
Okay.
You and I were talking a little bit before. I come from a large family, and I wish someone would have given me advice, because when I started out, I come from a working class family. So financial advice was for the people with assets in the past, but our group doesn't. We don't have a limit. If someone has $500 to put away, they'll get the same treatment as someone with $500,000, because they worked hard to put that money away. So
most important, very generous of your company. And I think a lot of the people on the line, not all, but some, this is very encouraging news for them. So I thank you for that. And just before we go for a break, Danny, will you be staying with us for the rest of the morning?
Oh,
in
yes.
case there may be a
For sure.
question that still will come your way. So we'll take a very sharp 10-minute break, get your cup of coffee, do your pit stops, whatever, and then we're going to go to our next expert who's become a friend of Seniors Action Quebec, Linda Hammerschmid, who is an expert lawyer in family law. So we'll be back in 10. So at 11 sharp. Welcome back, everyone. And now we'll start with our second presenter, Maitre Linda Hammerschmid, who graduated from the Sacred Heart High School, later became a member of the board, the board of the school as a director and then trustee, and then went to Loyola CEGEP before going to live in France for a year to study French. What a lovely way to learn French. Upon return, she went to the University de Montreal for 2 degrees, political science and law. And between 1982 and 92, she worked for 2 law firms and started her own law firm, which continues to this day. As a co-founder in 1984 and secretary of the Association of Family Lawyers of Quebec until 2012. So almost 20 years. She pleads cases before the Superior, Appeal, and Supreme Courts. And she was among the first group of family mediators in Montreal to have taken 2 courses under John Haynes. And she's also been involved in various groups, child abuse prevention programs, Violet Heart contesting the breed ban brought in by Mayor Denis Coderre, board member of the Lake Hughes Association from 2008 to 2019. And I know we have a partner organization on the line, Four Corners. So Lake Hughes is in your territory up near Mille. I've been involved, she's been involved with various groups. Oh, I'm sorry, I've already jumping here. And then she was a board member of the Bar of Montreal for several years. And many of you probably know Linda from her media exposure. She's been a frequent guest on CJD radio and TV, and certainly was a monthly contributor on Passion with Dr. Lori Petito. And that used to put me, that used to be my show I listened to when I was getting ready for bed. She's been on Global CTV with Mitsumi, and most recently this year with Mitsumi Takahashi on the new Divorce Act modifications, and been on CBC. She has a credit for a voice in the National Film Board animation short film Flux, and garnered many awards with that. She has given seminars to family law, financial seminars, including IG investments exclusively for women, Berkshire Securities, and the Côte St. Luc Men's Club. And I also know Cummings Center is also on with us today. Special interests, dogs, and dogs. She created a dog walking pooch in 2013 and attended the Super Zoo show in Las Vegas and the Global Pet Show in Orlando and the Pet Fashion Show in New York. And of course, that wasn't enough. Linda is also a bridge player, tennis, member of the Hillside Tennis Club since 1981, loves theater and dog sitting. And she's also created and administered the Mo West Dog People's Group on Facebook since 2013 and has 300 plus members. So you can see where her passions lie: family law, community, and dogs. And I think I would have to maybe put the dogs up first. Linda
Absolutely.
Linda has been a presenter for Seniors Action Quebec before, and well received and well liked, and no nonsense lady. It calls it the way it is. And you know, be it male, female, if you're wrong, you're wrong, and if you're right, you're right, and she'll go to bat for you. And we're delighted to have her, and she's going to talk about the importance of having wills, the different types of wills, reviewing your will, what documentation should be put together in advance to help you in the subsequent liquidation of an estate, and what potential heirs should be aware of. And without further ado, Linda, it's all yours.
Thank you very much, Ruth and Katsia. I'm very happy to be with your group again, and it's always a pleasure to address anyone who wants to learn about anything. For, you know, I'll talk about anything, even if I don't know what I'm talking about, because I just like to talk. And I just want to come to a quick point that Danny made before about RSPs and the transmission of them after death. It's important for people to understand that that rollover he was speaking about, it was for the spouses that they still are living with and civil union partners only. So if you're just living with your girlfriend, boyfriend, whatever you would, partner, whatever you'd like to call them, and it hasn't been formalized, then they're going to have the tax bite that could otherwise be avoided if they hooked up legally. So I just wanted to make that clear. You have certain decisions about wills to make in advance of doing that. And I encourage everybody that's listening and to tell their progeny, who they will speak to, I'm sure, sooner than later, that everybody, regardless of how much you have, needs a will, particularly here in Quebec. We'll get to the 3 forms in a minute. But what you should do is, if you don't have one, you should jot down some notes about who you want to leave whatever you have to, be it family members, friends, or charities. My particular case, I'm leaving my money to the Canadian Wildlife Federation and the SPCA. It's not that I don't love all you people, but animals are nicer than we are, so they deserve more help. But that's just my personal opinion. And then, of course, you have to decide how much you want to leave to everybody, or if you want to leave everything to nobody. You know, that's been known to happen too. If you want to spend every dime like in the movie Last Holiday, and you blow it all and then find out that your terminal illness was a mistake and you now have no money to live on, but that's okay. You also should know, and I'll get back to it a bit in a minute, but if your heir, one of the heirs that you put in your will predeceases you, you have to have made the choice while you did the will whether or not there should be representation. And representation means that if, I don't know, you leave your money to your sister and she dies and she has children, if you left it with representation, then her share will go to her heirs, however she determined them to be in her will or state. And if it's without representation, that means that if you left $25,000 to Aunt Frida, and she dies, Aunt Frida, before you, then that $25,000 will go to anybody else in the will, pro rata basis of how you left it. So that's an important thing to remember. Also, the timing of the inheritance, Danny may have touched on that a bit before, but it could be immediately, meaning
Sorry, Linda, you're muted. I don't know why. If you could just unmute yourself.
Am I back? I'm back. I didn't touch anything, so that's weird. Maybe there's spooks here. Okay, so you could leave money like, I don't know, $100,000. You leave $10,000 a year to Johnny because you know that Johnny is not that financially astute with his money. And if you leave all $100,000 to him right away, it'll be gone by the end of the year. And of course, you can also leave percentages to people and a lot of times also leaving it in a time for your children. If they haven't listened to this conference and you haven't imparted to them all this information, perhaps you should put in that they only get their inheritance when they're 30 or 40 or sometimes, you know, later on, because they won't properly invest it otherwise. The other important thing to remember is you should revise your will on a basically regular basis. I myself, I make a list every year at the end of the year as to what assets I have and what debts I may have, and attach that to a copy of my will so that people who, the liquidator and people are inheriting won't be fumbling around trying to figure out what's going on. And of course, every year when you do that, you may see that the amount of money that you left, which we'll get to in a minute, the types of inheritances you can leave, is insufficient now or not, depending on what the government takes from us and the interest rates that we're not getting and the amount of extra money we're spending on expenses, again, thanks to the government and cohorts. So that's important to know that, in fact, what you're leaving actually is sustainable and exists for the people that you're leaving it to. Now, in Quebec, there are 3 types of wills. And the one that I highly suggest that people should always have only are notarial wills. Why? Because notarial wills do not require you to run to court to have them probated as the other 2 forms of wills do. You can take it immediately to the bank. You can, you take it to whoever the liquidator is and they can go from there. But it's a much easier form. And as I said before, you should revise these wills based on situations at least once every 5 years, because certainly at a certain age group, you're going to have maybe more family members. Like Danny just had a granddaughter last year, and there's another one on the way. So you want to maybe in the new will put specific names in place. And in some occasions, you want to take some names out that you no longer want to leave any of your money to. If you could only just assign them debts, that would be good. It's important to know that minors can't make wills unless they're emancipated, but that's usually a rare case. So once you're 18, you should make a will. As for the notary will, it has to be read to you once it's been prepared by the notary, and then you're going to sign it in front of a witness, which is usually an office member of the notaries or another notary in his office, but it has to be witnessed. And if the testator, meaning the person that's making the will, yourself, is unable to sign, then 2 witnesses are required, and I mean to sign physically. The next type of will is called a holograph will. Sounds like something Disney would have in Disney World, but anyway. And it must be written entirely by hand by the testator. You cannot use mechanical devices. You can't type it out and then sign it, because that's the next kind of will. So it has to be handwritten, which is why you're going to be able, people are subsequently going to be able to verify your handwriting. And then that will has to be also, written out, but it doesn't have to be witnessed, is what I'm trying to say. And the other thing that's interesting about it is that you can do it immediately. So if you don't have time yet to get to a notary to revise your will, at least write down what you want to do in the event that on the way to the notaries, you're run over by a bus, or like yesterday, snowplows. Anyway, people in northern Quebec were unfortunately mowed down by one. So you never know when your time is up. So at least have something written. And then the next form of will is a will in the presence of witnesses. And there are 2 witnesses, and both are going to sign that they saw you sign. They don't have to read the content of the will. It's none of their business, but they do have to sign. And one of them usually has to sign an affidavit attesting to the fact that you saw the person, you know the person, that you know them, and that, you saw them, you witnessed them actually physically signing their will. There are several types of what we call legacies. One is universal. So for example, if somebody leaves, I bequeath my entire estate to my wife or husband, then everything that's owned by that person who just died goes to that person. You can have what's called general title, which entitles one or more persons to a percentage of the succession. And then you have a particular title, which is, I leave $25,000 to Aunt Frida and $10,000 to the SPCA and whatever other number you want. After that those amounts are paid, and they're paid first, normally speaking, at the winding up of the estate. What's left over goes to the universal legatee or legatees, depending on how many you've chosen. And if there aren't enough assets in the will at the time of the death, then the liquidator has discretion to prorate what there is based on what you had hoped people would inherit. I just want to open a parenthesis here and touch base that there is such a thing as survival of the obligation to pay alimony. So if a person dies and they were a debtor of an alimentary judgment for whatever amount of money, the people that were entitled to get that alimony can make a claim on the estate within 6 months after the death of the person. And in fixing the contribution, because it doesn't necessarily always have to be, if you were ordered to pay, I don't know, $1,000 a month, it doesn't have to be $1,000 a month, because now we're talking about the entirety of the assets, the net assets of the estate. So they can make a claim, and the contribution that the liquidator or a court will adjudicate is fixing that in contribution based on the needs and the means of the person who's making the claim, and the time usually required to become self-sufficient. The sum cannot, however, exceed more than half the share that could have been claimed in the entire succession if the person had died intestate. Dying intestate is not something anybody should really aspire to, because you could have during your lifetime had a fight with your brother, hate your father, whatever like this. But if you die intestate, by law, these people are going to inherit money from you. So if you do not wish that to happen, please make a will. People who are named in your will do have the obligation to either accept or refuse the will. Normally, you only refuse the will if the debts outweigh the assets and you don't want to be responsible for paying those debts. In order to make the settlement of your estate easier in advance, you should annually, as I said, review and prepare a list of your assets and debts and attach it to copies of your either handwritten will at the moment or your notarial will. You should list where to find all your investments and other accounts, bank accounts with the numbers, your insurance policy that Danny will get for you, where the car keys are. I mean, there's no amount of information that you shouldn't set down on 1 or 2 pages to make it easier for people who are, normally speaking, in a state of grief when you pass, hopefully, and are not thinking about, where to find things. But sometimes time is of the essence when dealing with certain matters. Like once the banks know that the person is deceased, assets will be frozen until the estate is liquidated. However, the government did come up recently with the fact that if you have joint bank accounts, for example, that they can no longer be frozen, so that the joint holder will have access to that money as it should be. List where to find important information, like, for example, passwords for your tablets and computers and all this. You might also want to think about including in your will, please destroy the hard drive, because I don't know what you're all going to have there, but some people's stuff they don't want seen necessarily by everybody else, or God forbid, if there's a contestation of your will in a courtroom. So you should make sure that those kind of things are dealt with in your will. And as an aside, in a divorce agreement, you should also be dealing with if there are photos and videos. You don't need to be Pamela Anderson to have all of that spread on the internet forever. So you want to assure yourself that these personal items don't see the light of day. You should also list contact persons and put together your pension statements, your RSP statements, your investment portfolios, everything that somebody and your heirs are going to need to know. The other thing that's really important, and many people don't like, first of all, dealing with the fact that they need to make a will. Please, people, understand, we're all going to die. Question is when and how we'll be at that time. So while you're all still corpus mentis, you should, figure out what you're doing, and then sit down the primary people that you're leaving your money to and explain to them what it is. And if, for example, you decided to cut out one of your children because, I don't know, they and not because you don't like them anymore, but maybe because they became millionaires or they won the lotto or they're all okay and they don't need the money as much as one of the other siblings does, but explain it to them, because if after you're dead they find out they're not in the will, that causes resentment between the ones who are going to inherit. And it could lead to an action in court by the person who was cut out that thinks that they nonetheless should be entitled to something. So explain things, because it's not supposed to be a big secret. And the more you talk about it, at least people will understand. I don't understand people as, oh, I can't talk about that as private or whatever. It's not private, because it's going to become open season once you're dead. And it causes a lot of fights in families when they don't understand what your real wishes were and your intentions. That's pretty much everything that is fit to print. And if anybody has any questions, I'd be happy to answer them. And if not,
Yep.
make sure you call Danny in his office to get yourselves in, because as I told Ruth during the break, even if the horse you feel has left the barn, you can still catch it.
Okay, well, yeah, four so far have trickled in. So I'll start with the first one. And I'm gonna start it with an allegedly. So,
Okay.
yeah, allegedly, someone heard this, that someone died, and this person who passed away left everything to a charity. Allegedly, the notary was slow in contacting the charity, and allegedly the family came in and emptied it, was what this person wrote. So then the question is, was the family allowed to do that if that was the case?
My first question is whether it was slow or not. I'm not sure about the charity, but are you saying that the will was not registered?
Yeah, that's what I'm trying to figure out. But the way I'm reading the question is that
Because if
the
it was
money
a question of the notary was supposed to contact a charity after the fact, well, they can still be contacted. There's no time limit on that. But if the notary didn't register the will in his minutes, that's a lawsuit, quite frankly, to the Chambre de Notaire and that particularly notary. And if he did register it, then the people weren't entitled to that, then the charity should sue them and get the money back or the value of it or whatever. People are greedy. You see, it's just wrong. For example, I have paintings here. They're not necessarily, Picasso's or anything, but I put on the back the name of the person to whom that should go, because I decide who these paintings should go to. Or if somebody can be, I really love that painting. Okay, so you're going to get that painting. And I put a name on the back. The more you settle, and the more you settle in advance, the easier it's going to be after the fact, and cut down on lawsuits and terrible things like that. I was on CJAD once, and somebody phoned in to say, his brother or sister, I don't remember which one it was now, had been taking care of the mother in her sickness up until the time she died, and she didn't leave me anything, and shouldn't I be in the will? And I said, no, you did nothing. Go away. Mom wanted to leave it to the other one who did the work. So, but you never know who's going to fight. People like to fight, so you have to be prepared for that. No.
Well, another question's come in. It's actually a clarification. They just want to make sure I'll read the question out loud. Did you say that people can choose to accept or reject a will? i.e., if they inherit debts, can they reject the will?
They can't just reject the debt. That'd be too easy. So either, let's say that, I don't know, the total amount of the estate is $100,000, but he owes $200,000 on a mortgage. So you're going to be negative $100,000. So everybody should reject the estate, because otherwise, if there's 4 people, they'll be on the hook for 25,000 each. Well, actually, they'd probably be on the hook for 100,000 total, and who gets to pay what someday a court will decide. So, and you can also, for example, in some cases in divorce and family patrimony, which overrides just about anything. In family patrimony, if there's a house that's had been owned and the people are separated, divorced, and there was a consent that says you're going to get this in the family patrimony, and then the person dies, and has also left an amount of money to the ex, or maybe the divorce isn't finalized yet, that person has to opt between, whether they want to receive the family patrimony assets or whatever the hell was left in the will, but they can't like double dip.
Okay. Another question came in, just to clarify, is residual, beneficiary, and universal legatee the same?
Yes, I would say yes, because residual means whatever's left over goes to that person, and universal, but universal also has a bit of a context. It's like the total assets. So yeah, the answer is yes.
Okay. Next question is, allegedly, again, someone was told by a bank that, so it's a joint account. And allegedly, the bank said to this person that that if someone passed away, half of it would be frozen. Half of the assets in the bank account would be frozen. Is that normal procedure?
Joint bank accounts no longer frozen on spousal passing. An article in the Suburban back December of 2022, and there's a law, and you can see it on the website justice.gov, gov.qc.ca, and look under couple and family and mesures pour les co-titulaires d'un compte bancaire, measures for co-owners of a bank account. No, they can't. I don't know what bank it is, but once you get your money, I'd go to another bank, or better yet, go to Danny and let him invest for it.
Even if the joint account is with a child?
Well, that could be something different, but theoretically, I don't think that there's a specification that it has to be a spouse.
Okay. And then,
I'm assuming that you were able to go with a notarial will, because otherwise they may want to keep it frozen until you probate the holograph or the will of witnesses.
oh yeah, actually, you just made me think of a question. Let's say someone doesn't have a notarial will.
Bad
Is
on
there a
them.
plan? Is there a plan B for them if they have the other 2 types of wills, or should they just?
What do you mean a plan B?
Well, if they don't have a notarized will, and do they need to do extra steps to make sure the other 2 types of wills kind of stand up, if you will? Is there extra
Well, the
things that they need to
handwritten
do?
will is good on its face value. But again, it needs to be probated, and somebody may contest if they don't like what's in that will, to say that's not my mother, father's handwriting, or they were nuts when they wrote it, or, because a notary has to ascertain that you're not, you may be nuts, but not nuts in the sense of legal capacity to write a will. And the other one has to have the witnesses. So long as they're done in the form that's set out by the civil code, the will is fine. But if you have time to make this question, to ask this question of yourself, you have time to get to a notary and make a will. So why wait, and why cause extra problems? Yes,
Very
it
good.
costs money to go to a notary, but there are a lot of young notaries that come out. So you can call the Chambre de Notaire and get a list of notaries and phone them and ask for their prices. And who knows, depending on your situation, maybe you're entitled to, I don't know, legal aid. I'm no expert on that, but some sort of stipend to help you with it. But you don't have to spend thousands of dollars to have a notarial will. That's
Is
all
it
I'm
better
saying.
to have a notarized will in French and English or in both languages?
Well, there's
Does it
another
matter?
subject for Bill 96.
Yeah, sorry, I had
I
to throw
don't
it
know.
in.
I have to be
Sorry.
honest, I do not know what the notaries have decided about that yet. But I'm
Mhm.
pretty sure that an English will at this time is still valid. And God willing, that goddamn law will be set aside by somebody, notwithstanding that it's notwithstanding. Don't get me started on these idiots.
I know. I was like, do I ask or do I not
God,
ask? I'm
I
like,
hate them.
All right. Okay,
Okay.
next.
Right.
Whoa,
This is
don't
the last
drop your
question.
computer.
This is the
Yeah.
last question because
It
we
is the
have,
last one. It is.
I'm back. Okay,
You're back? Okay, good.
you're back.
How
Yeah,
many
don't
years
get me
of
started.
income tax-
I could just break something.
I know. Well, I'll ask you the last question. How many years of income tax returns do we have to have kept?
At least 4, 7 is safer. And I've just spent January cleaning out, I'm a bit of a pack rat. I had stuff back from 2002. So I said, they're not coming after me anymore. And so I finally got rid of all of that stuff. Takes too much room, the paper, but you should keep it just in case. They can go back 4 years legally and ask you for more money because they decided God knows what wasn't a deduction or whatever. But contest everything.
Thanks. Thanks, Linda.
My pleasure.
Linda, thank you once again. Not only was it informative, but it was very entertaining.
I do my best.
Thank you kindly.
As I like to say, I'm a hoot.
I don't think they want to put you and I in the same room.
But aren't we in the same room virtually?
Well, I mean, in front of government together.
Oh, okay, yeah.
That would be something. Anyway, very informative. Thank you kindly. It was great. Really appreciate it. So people do look into your will situation. And one thing I did want to add, Ann Soden, S-O-D-E-N, has an elder legal clinic. She does not charge for seniors. She is a lawyer. And you can phone her and see where you can get some help if you have a serious financial restriction. So maybe she has some networks that can help you out. She's at the, she's on Atwater. I don't have it handy, but when Samy is talking, I will get it on my phone and I'll put it into the chat box for you. So without further ado, last but not least, I'm very anxious to hear what Samy Staltari is going to tell us. He is a founding member of a law firm with a focus on family law from 1998 till June of 2022. He has worked as a lawyer in Linda Hammerschmid's office. He regularly appears before the Superior Court of Quebec in matters of child custody, division of property, alimony, provisions for cost, which I don't know what it is, and also pleads before the Court of Appeal in Quebec Youth Division and the Tribunal Administratif de Housing Administrative Tribunal. I suspect that might be the new term for the rental board. If I'm correct, maybe Samy will tell us when he starts. In 1998, I've got swearing in the Quebec bar. So I guess that's when he officially became a lawyer. He got his Bachelor of Law at the University de Montreal. His community involvement from 2021 till now, he's been a member of the board of directors of the Family Law Association. Also, the Association of Family Lawyers is a nonprofit corporation founded in 1985, bringing together 400 to 500 members in the most judicial districts of the province of Quebec. 15 directors sit on the association's board of directors, which meet monthly. The association organizes subcommittees to address various aspects of the practice of family law. From 2018 to June 2022, the member of the board of directors and ombudsman for Separated Fathers, Inc. Separated Fathers is a nonprofit referral organization recognized by separated fathers and men in the context of family transition, which is drastically needed. I support that concept. The organization promotes the well-being and health of fathers and their commitment to children and the community. And in addition to being a member of the board of directors, he regularly gives legal clinics on a pro bono basis. So without further ado and all that, Samy, welcome. Thank you for agreeing to do this for us. And I'm looking forward to hearing what you're going to tell me when the role of the liquidator and settling an estate and how I find the documents and what receipts are required if somebody has expenses such as the liquidator. And I'm turning it all over to you. Thanks.
Well, good morning. Thank you for having me. It's a pleasure to be present. I believe that these sessions are very important. One of the biggest frustrations that we see in private practice when clients come to see us is the lack of information or accurate information. Everyone believes they have the information, a bit like Danny Sirgnano mentioned earlier this morning, what I know and what I don't know, and what I don't know that I don't know. And it's important that we be informed. And as Linda mentioned also during her presentation, at times people don't want to talk about these issues. So with all due respect to my predecessors, I'd like to try to attempt to meet the adage, you save the best for last. So thank you, Linda. Thank you, Danny. My presentation will be in two main parts. To begin with, what are the main steps in settling an estate, and what is the role, or what are the roles and the responsibilities of the liquidators? So unlike Danny and Linda, who had positive issues to speak about, I'll be speaking about the loom and gloom and begin with what to do when someone passes away. I always find it's important to verify that they are actually dead, otherwise my presentation here will be moot. So when one passes away, we are confronted with a multitude of emotions and feelings, and notwithstanding all that, we are obliged to carry forward certain important steps and take some very important decisions that come with grave consequences at times. The immediate is the planning of the funeral, and if it is not mentioned in the will, what are the wishes, then it's left up to the liquidator, and the liquidator has discretion as to what will be the funeral arrangements. Of course, the liquidator should, for harmony's sake, try to respect the wishes of the deceased as well as those of the family. It's important, as was said previously by Maitre Hammerschmid, to have a list of what we want and where to find documents. But there are certain government organizations that exist to help. For example, when determining what are the funeral arrangements, and we contact funeral companies, it's important to know if there was a pre-arrangement made. And if we are unaware, the funeral company can be asked to verify, as there is a registry for pre-arrangements, so that we know who is the funeral company that has the contract and what were the arrangements that were made. In the past, we used to hear the term that so-and-so, my brother, my sister, will be named the executors of the will. The executor is the person that carries out the administration of the succession until it is fully resolved. The term is no longer executor, it has been replaced by the word liquidator. The liquidator has certain fundamental steps that have to be carried out in order to properly manage the property. And what's important is that the liquidator know that their duty is to act in the best interest of the people that will inherit. At times, the liquidator is not an heir, and that's when it becomes a little bit more complicated, because the liquidator is not there to do what is good for them or what is fast, what is simple, but what is in the interest of the heirs. Where we begin as a liquidator is to obtain the proof of death. We obtain the certificate of death or the act of death at the office of the Directeur de l'État Civil, and this can be at times frustrating because of the delay that is involved in obtaining the certificate. Obtaining the certificate is in principle not complicated. We can go on the website of the Directeur de l'État Civil and fill out the form online, pay a fee, and the certificate of death is issued. It's important to know that the attestation of death that is given by the doctor that pronounces the death of the individual, or the declaration of death that's prepared by the funeral directors, those are not the requisite documents that will be accepted by the banks or other institutions. We must obtain the death certificate from the Directeur de l'État Civil. With that, we proceed with, as a liquidator, with the next step, which is to do a will search. Now, Maitre Hammerschmid has given us the three forms of wills that exist in Quebec: the notarized will, the will before two witnesses, and the holograph will. So the liquidator's first step, or the second step at this point, would be to do a will search. And there are two possible registries that have the will, which could be la Chambre des Notaires or le Barreau du Québec. It is one form that is filled out online for both. The result will tell us who has the will. It won't give us the will. So it'll just tell us this notary, and these are his or her coordinates, has the last will of the deceased. It is then up to the liquidator to contact the notary or the lawyer that holds the will with the proof of death, the death certificate, in order to obtain a copy of the will so that the liquidators can execute their mission. Notwithstanding the fact that there is this will search, the liquidators still need to verify that there is no other will that exists that has not been registered. We've heard of the example of the holograph will, or a will made before witnesses that has not yet been published. It is the last will that prevails. So if there is a will that was notarized and in 2021, and there is a holograph will that was done yesterday morning, the one of yesterday morning will be the one that prevails. While looking for documents, the liquidators should verify for life insurance policies, as we've heard this morning from Danny Sirgnano, as well as to verify if there is a marriage contract. Marriage contracts or a contract of civil union can have clauses that have a transfer of property that is made, where in the marriage contract it is possible to donate to our spouse a gift that takes effect when the deceased dies. By spouse, as was said this morning, we refer to somebody who was legally married or in a civil union. If the liquidator does not find a will or a marriage contract, then the law will dictate who inherits the property based on the personal situation of the deceased. Meaning, does the deceased leave behind a spouse? Does the deceased leave a spouse and children? Does the spouse and no children? The law provides who will inherit and the proportion that they will inherit. Is it 2/3, 1/3? Hence, this joins what Maitre Hammerschmid mentioned earlier this morning. It's important to have a will to specifically avoid these issues. We can easily understand that someone may prefer to advantage their spouse rather than spouse and parents or siblings. So the will is the way to go by all accounts. If the will is not made before a notary, meaning it is a holographic will or a will before witnesses, the law requires that the will be probated. That step essentially is done by the court or a notary, and it is to verify and to attest that the will that we have in front of us is in effect the last will, and that it follows the requirements for that specific will. This morning we heard the example, you can't call it a holographic will if it was typed. Well, that'll be one of the conditions that we will look at if that's what we are probating. The notarial will does not have to be probated, as was already discussed. I don't want to add more other than it certainly merits to have a notarized will. We avoid this step, we avoid this cost. The liquidator, at this point, we know who they will be because we have read the will or we verified there is no will, and so the heirs will be the liquidators by default. The liquidator has to now publish a notice to, and it's entitled the Notice of Designation of Liquidator. So it is to be published in the government registry at the Registre des droits personnels réels immobiliers, and it's to advise everyone that we are the liquidators and we have the authority at this point. If there is any immovable properties, land, homes, condominiums, chalet, etc., the same notice needs to be published at the land registry office. Again, for the same reason. The purpose is clear. Any third party and the public at large will know who has the authority to act. The heirs need to be determined and contacted. The liquidator must identify and contact all the potential heirs. As I mentioned, if there are no liquidators that are named, all the heirs become liquidators, or they can vote to the majority who will be named liquidator. Up until now, it seems academic, but now we're going to get into the more practical concerns of what the liquidator has to do. So, as we've already heard this morning, there are bank accounts. So the liquidator needs to proceed to closing bank accounts and open an estate account. This will allow that monies coming in post-death are deposited into an account. It'll give access to funds for the liquidator to pay out bills that come. We can easily understand, for example, elderly parents pass away, naming one of the children to be the liquidator. Well, we want that child to continue paying the rent for the surviving parent, to pay for medication, etc. We have access to funds in that sense. Also, it'll allow us to deposit monies that are coming in post the death. For example, a tax refund or any reimbursement of sorts. We have to be able to deposit them somewhere, and it'll allow the liquidator to have access to funds to pay bills as they come due. In opening the account, again, the bank will ask us for the certificate of death, the will search, and a copy of the will. The liquidators at this stage, if it hasn't already been done, should cancel credit cards for obvious reasons, verify if there are safety deposit boxes and access to them, and inform pension funds of the death of the person so that there will be less paperwork and less funds to reimburse to the authorities and the government later on. Earlier this morning, we heard and we took note of the good advice that was given that every year to update the list of assets and liabilities. Well, that'll certainly help the liquidators who have that obligation, which is called the inventory. The inventory is a complete list of all of the assets. So there we have to include the home, the houses, cars, RSPs, bank accounts, investments, and so on, as well as having all the debts. So lines of credit, credit cards, personal loans, personal debts, mortgages. These have to be included in the inventory. The liquidator publishes a notice called the closure of inventory. And again, this notice is published with the RDPRM. Now, it's important to note, we don't publish the actual inventory list. So it's not public that'll know what were the assets or what were the debts. It's the notice that the inventory has been done. So it's published in two places. It has to be published in the RDPRM and in a local newspaper that was distributed in the area where the deceased was living at the time of their death. We've all heard of the sentence that there are two things that are guaranteed in everyone's life: death and taxes. Well, the liquidator gets to have the privilege of having both of them at the same time. The liquidator is dealing with the death of someone, usually a loved one, and having to pay taxes, because after all, what are taxes for? So it'll allow the liquidator the funds, if he has the estate account, to pay taxes as they come due. And it's important to know that the liquidator files the taxes for the last year that the person was alive. And the liquidator may also have to file taxes for the estate. For example, if after the death, monies have been invested, interest, as Mr. Sirgnano mentioned earlier this morning, will be taxed. There is a subsequent tax return that has to be filed. In order to assure that there are no unpleasant surprises that follow, the liquidator should obtain from the tax authorities certificates that prove that no more monies are owed for past tax years. No one wants to be told, oh, you've been assessed or reassessed, and this is now what your loved one owed. Once we are in receipt of the certificate authorizing the distribution, the liquidator should proceed to the payment of the debts. It seems pretty straightforward. We know if there are arrears of rent, property taxes, this is the time that they have to be paid. And as we mentioned earlier, excuse me, not as we, but as Mr. Hammerschmid mentioned earlier, we can find ourselves here with a claim for child support or spousal support from an ex-spouse, a claim for compensatory allowance. They have to be included in the inventory that the liquidator is carrying out. The role of the liquidator is winding down at this point. After the sums have been paid out, the liquidator proceeds to prepare a report, which is commonly called the final account. And this report is written by the liquidator, or signed by the liquidator, I should say. And it explains to the heirs all the steps that were done and what were the assets at the opening of the succession, what debts have been paid, and what is distributed. When I say what has been done, at times there can be, in complicated situations, lawsuits have had to be instituted, settlements were paid, assets had to be sold off. So they have to explain what was the situation and how the money is distributed. Essentially, this is where the liquidator renders an account of his or her administration of the estate. So we've heard a lot of what the liquidators do. We need to know now who can be a liquidator. Well, the liquidator can be anyone who is of the age of majority, so an adult, and who is not incapacitated. It seems straightforward. However, the reality often surpasses fiction, and we've heard of a good example and advice to review the will and to update it. Well, this is where one example of the need to do so. Often people, for example, that are married will name their spouse as the liquidator. Well, that's good when we are young and healthy and all there. However, with time, sometimes with coming of age, illness takes over and our mind may not be as sharp as we would like it to be, and perhaps a protective regime is opened. Hence why they will then be excluded from being liquidator, which is not what was the intention of the person who drafted the will, but they find themselves in this situation. The other way to resolve this is to name more than one liquidator. And that can be prudent so that we have a backup liquidator, so that if one is not capable or if one resigns their position as liquidator, and I'll get to that, we are not at a total loss. There is someone else that takes over. The notary who drafted the will can, if he or she chooses and accepts, can also be the liquidator. However, this has to be done free of charge. So not so sure how many notaries who draft the will would want to do so, but it is a possibility. Many professionals can offer their services as liquidators, and they will be entitled to be remunerated. We can think of a lawyer, an accountant, a notary who has not drafted the will, mind you, can be the liquidator. Many financial institutions and trust companies also can act as liquidators, and some offer their services to this. The condition is that they be registered with the Autorité des Marchés Financiers, which is a prudent choice. The liquidator is to be named in the will of the deceased and either identified or can be identified, meaning I name my brother Jonathan to be my liquidator, or I expect that my eldest son be the liquidator, can be identified. It is very prudent to be as precise as possible. For example, I name my spouse. We want to be sure that by spouse, we mean the person that is married, and not that should there be a separation or a divorce, in the eyes of one of them, spouse is someone else. We want to avoid that. And notaries very often, and lawyers who will draft wills, will give you the advice to specifically designate the person. As I've already mentioned briefly, if the will does not contain a liquidator, which is quite rare, then the heirs become automatically the liquidators. Liquidators, as we can imagine with all what I mentioned, are quite busy. There's a lot to do, and they have a right to be paid for the work that they have done, and to be compensated for their time. However, if the liquidator is also an heir, then that person cannot be remunerated for their time unless the will states otherwise. Regardless if the liquidator is an heir or not, the liquidator does not have to pay out of his or her own pocket for expenses that they have incurred in the settling of the estate. So travel costs, professional fees, if they've had to hire an accountant, a lawyer, a notary, if they've had to hire people to carry out repairs or work on property, they do not have to disperse that themselves. They are entitled to be reimbursed. The reimbursement must be reasonable, so you don't necessarily need to travel in first class to go to Ottawa if you have to get a document of some sort, but it has to be reasonable, bearing in mind that the obligation is to the heirs. If the heirs do not believe, or if the liquidator has not conducted himself in the best interest of the heirs, the liquidator can find himself or herself in a situation where the heirs will ask the court to remove him or her as liquidator and appoint someone else in their place. The liquidator is not obliged to accept the role of liquidator, save and except the situation where the liquidator is the only heir. If there are other heirs, the liquidator can resign his position as liquidator at any time. However, the liquidator is to avoid putting himself in a situation where he resigns at an inopportune time that could possibly harm or damage the settling of the estate. The role of the liquidator is quite complex and at times can be extremely time-consuming. To avoid errors, to avoid unpleasantries, it's highly recommended that the liquidator be assisted by notaries or lawyers or professional accountants in order to avoid difficulties. We have also heard this morning about situations that could arise when people are caught by surprise that they are not the liquidators or they are liquidators, as we heard from Mr. Hammerschmid earlier this morning. While it's not in the law and there is no legal obligation to do so, it is recommended, I'll use the word, that the liquidators be advised and informed of their role It's not necessary to advise them exactly of what are all their powers or what they stand to inherit. And it is important that the will be reviewed in order to make sure that the person that we chose as liquidator is still the person we want to be the liquidator. And we tend to believe that it's because, well, we've had a falling out with this person. We want to keep them as far as possible from us. That can be a situation. But it could also be that life has changed, circumstances have changed. Someone who was very close to us and we thought would be a very good liquidator is now living on the other side of the Atlantic Ocean. Well, perhaps we may want someone closer to us. Also, in talking of distance, if the liquidator is outside the jurisdiction of Quebec, there could also be tax implications of the estate as well. We also want to make sure that the liquidator has the required capacity to handle this. And it is possible to have more than one liquidator. It can be complex at times to carry out, but it is possible to name one liquidator who will take care of the business that I have, and another liquidator who will take care of my funeral arrangements, and a third liquidator that will take care of the remainder of my property. There can be some overlapping, and that could cause certain complexities at times, but it is a possibility that's available to us. And as I've already stated, it is important, as far as I believe, that there be an open communication and an updated of the will so that there are no unpleasant surprises. Thank you.
Thank you very much, Samy. That was very informative, and questions have been coming in. We're right at the closing time, but the questions are very important, so we are going to extend it and let you have the opportunity, Katya, to pose the questions, and they're very important ones. So I think get the question out in as brief an answer, but as complete as possible. And we'll try to go to let's say we'll aim for 12:15 to close down. But if we still have one more question, we'll take it. So I'll turn it over to you, Katya.
Okay. Hey, Samy. So one quick question that kept coming up. You said that there were tax implications if the liquidator was a non-resident of Quebec or but can a liquidator live outside of Quebec and Canada? And do they have to be a Canadian citizen?
In order to be a liquidator, there is not the requirement of citizenship. To be a liquidator, what is required in the law is that they be of the age of majority and not incapacitated.
Okay. Next question that came is regarding the liquidator. How much do they get, and do you set the percentage or monetary value to what they receive as the inheritor, or who determines that?
It can be specified in the will what is the form of remuneration and how much it is, or the liquidator can, if they are not an heir, invoice the estate, and the estate will then have to either accept or refuse. Remember, we give the report at the end, and the heirs will have to accept. So it's important that that be clarified from the beginning, because we don't want to have done all that work and not be remunerated if we expect to be remunerated, because you won't be able to get your time back.
Okay. Next question that came in is someone has named, we have named an executor in their will. Is that the same as a liquidator?
It is. It used to be called the executor, and the law was modified and just replaced the word executor with liquidator.
Cool. Another question that came in is, can we prepare a codicil instead of revising a will concerning changes of liquidator?
Yes. Ruth said to be precise.
Yeah, you're like to the point. And the other question that came in, which kind of ties to what was asked before, it's again about joint accounts, personal bank accounts. And this person is saying that her adult daughter, or their adult daughter, I should say, sorry, is also the executor liquidator. Does that mean that the bank account will be frozen when this person passes on?
It is my understanding that it is 50% of the account that will remain frozen.
And can you just repeat where people have to register proof, I can't speak English, proof of deaths and where the death notices should be posted. There's a bit of confusion there.
Yes, okay, so we apply for the death certificate at the Director of Civil Status, which is the same place that we would apply for a birth certificate or a marriage certificate.
Mhm.
Okay, so it's the Director of Civil Status. We go on their website and we can register, we can apply for it. And we register all the different notices that we have to register at the land registry office for removable properties, or at the government site of the real and personal rights, the RDPRM.
That was it. That was the acronym they wanted.
Yes.
A really interesting question came in just a while back. What resources are available to the liquidator to help them navigate the process or processes of, I guess, liquidating a will?
That's the difficult aspect, is that they're responsible for all of this, and if they don't get professional help, they are a little on their own. There are some government sites that could help. I know that Revenue Quebec has a site where they can answer some questions, but the information, while it is very, very good, is general. It's not specific to your case. That's why I believe it's important to be assisted with an accountant and a notary or a lawyer.
Get the whole team on board. Okay. And 2 questions have come in about probates. Does a will prepared by a lawyer, does it need to be probated?
Yes.
And the next one is, does a holograph codicil need to be notarized? And then I can't read this. Please speak to holograph codicil. Does this mean notarized will must be probated?
Can
Oh,
you repeat the question for me, please?
never mind. They just typed in, ignore the question. Linda just answered it. So
Okay.
all good.
Thank you, Linda.
Yeah, thank you, because I was trying to make sense of it.
I don't share my fees.
And I think that's pretty much it. That's it.
The one thing, I think maybe I missed it, but I don't think I did. I have not heard today any mention of mandates, because I know when I recently did my will, my notary asked me if I wanted to name people for certain mandates, be it my housing needs as I got older, my financial needs, and also medical needs, which I have done, and it's 3 different individuals because they have different expertise. Is that important to do? Is that necessary to do? Could somebody answer that? Anybody? Linda, Danny, Samy?
I'll begin if that's okay. I
Sure.
believe it is very important to have the mandate. Actually, the mandate, if we stop to look at what it does, I believe is perhaps more important than a will. And I'll explain in a moment. If my heirs cannot agree among themselves what to do, and they're going to argue and squander their money, it's their money that they're squandering. I'm not coming back from the dead. If I'm incapacitated, I could come back. It is possible that I'm in a situation where one is, for health reasons, incapacitated for 3 months, but then we'll be able to get back to an active and productive life in return. I want to know that my assets are still there and that whoever was taking care of me didn't squander it on whatnot. The mandate is fairly new in Quebec law as opposed to the wills, which have been around, and a lot of people are more familiar with laws, with the wills than with mandates. The mandate in case of incapacity is a completely different act, a completely different legal document than the will. And there are several types of mandates. We can give a general mandate where if I'm away from my office for 3 months, I'd like so-and-so to run the office. I could also have one in case of incapacity where, and even there, I can have different mandataires. So I can have someone who will take care of the decisions regarding my health, and someone will take care of my finances. And even the finances can be then separated some more. This person will take care of my business, this care of all my other financial needs, and so will take care of my personal and health issues. But yes, it is something that should be done and updated as well as the will on a on an on-need basis. I don't know.
I don't want to keep everybody back, but maybe there's some brief answer to this question because it sort of it's important and it's arrangements. We now have this medically assisted death or dying, and there's forms that can be filled out in advance. Would that be done with your notary at the time you would do a will? Is it done with your doctor? Or is it as simple as going on, taking the bloody print copy off the computer, the government's website, and you fill it out? Any recommendations, anybody?
I'm not
Linda?
not an expert on it, but I do know that unless there's been changes that I'm not aware of yet, that some decisions cannot be made in advance, but rather there are certain medical criteria that have to be fulfilled before being able to choose. But
So
I
then
can't go
that
further.
would be
I'm not
very,
sure.
so then I guess it reinforces, that's one of the reasons I put a daughter who is a nurse in charge of my medical decisions. She knows what I want. So I think by giving the medical mandate, hopefully can address that. Would you agree?
It certainly will help. As I mentioned, I think it's
Okay.
important that we pick the right person for the
Yeah.
specific act that we're asking for. For example, I may not want my accountant to make the decisions regarding my health, but I really would like my accountant to be the one who makes the decisions regarding my investments.
Exactly, exactly. Well, I think due to time restraints and keeping you experts, okay, that's called an MDA and, oh, yeah, it's okay. Thank you. Due to time restraints and keeping you experts on longer than I had asked, I want to thank you, Danny, Linda, Samy, for an excellent, excellent presentation. I mean, I think it's one of the best that we've had. So we're closing down our series on a real high note. So I really appreciate it. I will be in touch with your office, Danny. And Linda, I will be following up with a phone call to you in the next day or two. And I want to thank all the participants who, some of them have been regular, faithful registrants who've come on right from back in September, I guess we started this. So I thank you all for your support, your interest. Hope the information has been good for you. And I thank Agape, Cummings Center, Four Corners, Shamedy Seniors Club, all the organizations who have got their members signed up, or they're all joined together in a wellness center watching. So you got certain numbers, but there are more people watching than we're aware of. So I thank you for putting that extra work into making it accessible for those people. And I wish everybody a great spring, a great summer, and hopefully we can do more webinars in the future, but I think people need a bit of a break. People are a little zoomed out. And thank you all kindly, and it was great. So appreciate it all, and I'll let everybody depart.
Thank you.
Thank you, Linda.
Bye-bye, everyone.
Thanks,
Bye.
Samy. Thanks, Danny.
Bye-bye.
Nice meeting you
Thank you.
both.
I have to say that